between TW and others and London Borough of Hillingdon and another, part third.
Sorry to deprive you of 5 minutes of your precious time.
My lords, my lady, on reflection, I am going to take 45 minutes this morning, not 30.
If that's all right with your...
I can sit with my learned friends, and they've all agreed that can be accommodated.
Good.
Indeed, it's in keeping with the original planners.
Mr. Burton, can I urge you to keep your voice up this morning?
Certainly, yes.
It was dropping.
It was indeed, yes. I'm terribly sorry about that. I was actually recovering from a throat infection, which I feel a lot better in relation to this morning, so it shouldn't be a problem. But of course, please do remind me if it becomes a problem again. So yesterday I was dealing essentially with the proportionality defence and the two issues which are raised specifically in Mr. Gullu's appeal, and indeed are the two main points taken by Mr. Rutledge in both of his cases, which concern, first of all, the extent to which the relevant difference in treatment has been assessed or considered, or any evidence is provided in relation to it, and the second related point, which is about safety valves or mitigation. And they are, of course, to some extent connected. And I'm therefore going to spend about 15 minutes on those, just recapping a little bit for the purposes of giving the court some references I didn't give yesterday, and just to make it absolutely clear what Mr. Gullu's case is in relation to those 2 points, and trying to make it also clear to what extent there is genuine commonality between the two appeals. Then I will move on to Mr. Mostyn's reasons, Mr. Justice Mostyn's, I do apologise, reasons for finding that this measure is proportionate. I hope that won't take too long in light of what we've said about the two main issues, before then moving on to the PSED, which will take very little time, I would hope, and then finally on to AMBIT, which I envisage taking only about 15 minutes on. So dealing then first with the point about assessment and evidence, if I could ask the court to turn up Mr. Gullu's skeleton argument at paragraph 67. We see in paragraph 67 and 68 how it is that Mr. Gullu puts his case on this point. At 67, reference is made to the authorities, principally Elias and the Secretary of State for Defence, and then JFS, the Jewish schools case, both of which are in the bundles. But the point I'm taking in 67 there is very much squarely directed towards the absence of evidence being available to make out the justification defence. And the relevant quotes taken from those cases, in particular the Elias case, are designed to demonstrate the legal and practical difficulties that a court is likely to be confronted with where there hasn't been a proper prior assessment by the decision maker. And they can perhaps be summarised in two ways. One, there isn't any assessment of impact, and second, there is therefore no consideration of possible amelioration or mitigation in the context of that impact. And at paragraph 68, we make the point that those difficulties are present in this case. There was no evidence regarding the number of refugees registered on the scheme before or after the introduction of the criteria, and therefore no evaluation of the likely impact of the criteria on refugees. An exercise the respondent did carry out in relation to certain other groups, principally ethnicity.
Well, you're sliding around a bit between the
refugees
the protected group, which is not refugees,
yes,
but is non-UK nationals,
yes,
and refugees, which may have a status for the purposes of Article 14,
my lord.
but don't share a protected characteristic.
My lord. Two observations, if I may, at this stage. The first is that the analysis of paragraph 68 applies equally, with one small caveat that I will return to in relation to non-UK nationals, so the protected group for the purposes of the Equality Act.
Say it again, say that again, sorry, one.
The analysis in paragraph 68
yeah.
applies equally well to the protected group, non-UK nationals, as it does to refugees. There is the same absence of evidence of impact, and there is the same absence of consideration of mitigation. And I'll make that good when I come on to the evidence, if I may. The second point is, just to flag it, we covered some of this yesterday, that in paragraph 65 and 66 principally, I should add, I point out 4 reasons why, in any event, in a freestanding sense, it ought to have been obvious that the consequence of the residency criteria would be detrimental or disadvantageous to refugees per se.
I see why your first point is an answer to my Lord's point. Well, why is your second point?
Well, because if you were in a situation, just for the sake of argument, where you were only concerned with an Article 14 status case of discrimination, the same point applies.
Well,
If
that's Article 8.
Article 14, it's in the...
Well, Article 8 stroke 14.
Yes.
But if we're dealing with the Equality Act point,
Yes.
I understood your submission yesterday to the, if I've understood correctly, to the effect that if there is unjustified indirect discrimination against non-UK nationals, one possible course of action for Hillingdon to take is to ameliorate that indirect discrimination as regards the worst affected of that group, namely refugees. That I understood, and that, as we I think said yesterday, that goes to remedy.
Yes.
Possible remedy.
Yes.
It doesn't go to either the question of indirect discrimination or justification, does it?
Well, I put the case this way, that when you're looking at this claim solely through the prism of the Equality Act, then of course you're concerned with non-UK nationals. And the points I'm making about the absence of evaluation apply equally well to non-UK nationals.
I understand.
That's your first point.
If you see the claim through the prism of the Human Rights Act and Article 14, again, the same principle applies. Now, the legal difference between the two is that the public sector equality duty and the Equality Act does not protect refugees as a defined class. So that may be one reason why one might be more forgiving of a failure to examine refugees independently when thinking about the consequences in law of this particular rule. But it's only one reason. And the reasons I've set out in paragraph 66 are there to demonstrate why, even if one is only concerned with this claim through the prism of Article 14, there are, in any event, very good reasons why one would have expected the decision maker to consider.
Well, all right, but you've been very reasonably systematic so far, and you've not been taking your Article 14 claim. It's not helpful to ask for you to slip into your Article 14 claim because it confuses the analysis.
I understand.
So, am I right in saying that your only answer to my Lord's point that you must stick with refugees, or that you were slipping between refugees and non-British nationals, is to say, well, the analysis in 68 applies equally well to non-UK nationals or non-British nationals?
My lord, absolutely. You're
Right,
absolutely.
okay.
Absolutely. The principal observation I'm seeking to make at this stage is how the case is being put by Mr. Gullu, which is very much grounded in the absence of evidence in relation to the relevant discrimination. It is not, as has been suggested by Mr. Rutledge, an argument that as a question of principle, the failure to consider automatically means the discrimination cannot be justified. So I'm simply making that point to make it clear that insofar as Mr. Rutledge is interpreting the manner in which Mr. Justice Supperstone approached this question in the TW case, where Mr. Rutledge seeks to suggest that on a proper interpretation of paragraph 59 of Mr. Justice Supperstone's judgment, he is in fact approaching the question as one of principle, rather than a question of practical legal difficulties, as is identified in the Elias case. That does not carry over to this case, because that is not how I put my
You have
case.
said that you can have a retrospective justification.
I do indeed. The qualification is Lord Kerr's comment to paragraph 52 in Re Brewster. So leaving aside the argument of principle, the second argument advanced by Mr. Rutledge in the context of the assessment question, or the evidence question, is he tries to meet it on its facts. So if I could ask the court to turn up the skeleton argument, Hillingdon in the Gullu case. And ask the court to turn to paragraph 25. Again, I'm going to be as careful as I can to not confuse the two claims here, but to some extent, I'm just making an observation at paragraph 25 that it's agreed between the parties that refugees are not a racial group in themselves. Parking that for the time being, and then moving on to what Mr. Rutledge says about non-UK nationals. Essentially, if I can summarise this way, and we've looked at these documents in the course of Mr. Rutledge's submissions, the paragraphs 28 and 29 reference is made to the fact that Hillingdon certainly did assess the impact of the rules from an ethnicity perspective, white, BME, other and unknown. And in paragraph 29, it said in terms that the assessors expressly address the proposed residence condition and estimate the impact such a condition would have on those four groups, comparing 10 years with lesser periods. And that's, of course, absolutely correct. There's no issue about that. But then moving on to the relevant difference of treatment, in this case, non-UK nationals. Mr. Rutledge refers to comment in the consultation document, so not part of the reasoning of the decision maker, where it had been suggested that it might be unfair, the rule that is, on people coming into Hillingdon from other countries. And then cites again now from the assessment itself, the paragraph, or the passage cited in paragraph 30, which we again looked at briefly in the course of Mr. Rutledge's submission. And there is an emboldened part there. In addition, it will mean new residents arriving to the borough and or country will not be able to access the housing register for a period of 10 years, which in my submission merely describes the rule. It is not assessing the impact.
Well, that's not quite true. If it said it will mean that new residents arriving to the borough, that is obvious. That just describes that that's what it's meant to do, for goodness sake. But the and or our country is, however briefly, a reference essentially to non-British nationals.
Yes.
There could be a tiny group of British nationals who've been living abroad, but you can ignore them, I think.
Yes.
So it's not right to say it isn't addressed at all.
Perhaps it's an acknowledgement that there might be a group of people affected, but it doesn't go on to say in what way, or what this...
It does say in what way.
Well, in the sense that they won't be able to access the register, yes, I appreciate that. But what it doesn't go on to do is then assess what that impact means for that group, in the same way that they do for the ethnicity groups, for example. So there's no contemplation of what the numbers are and what the difference, for example, between 5 and 10 years might be for that group. They don't assess what their settled non-UK national population is. Indeed, people coming from other countries aren't even necessarily entirely equivalent to non-UK nationals, of course. Obviously, my submission is not that no reference at all is made, at least alluded to this problem, but it doesn't constitute an analysis, in my view. And keeping in mind this is not a question of principle, this is a question of what evidence it produces for the purposes of the defence of justification advanced by Hillingdon, it's not very helpful in my submission. Of course, that ultimately will be a matter for the court. But that unhelpfulness is, in my view, repeated in the second citation in paragraph 31.
Well, in effect, your point is that the impact assessment has acknowledged an adverse effect on people arriving in our country, but it has not then gone on to justify that negative effect which has been acknowledged.
My Lord. And in particular, without any reference to possible alternative measures, insofar as they might be worth consideration, which they did do in respect of other groups. And just therefore to complete that submission,
But do you also have to deal with Miss Murphy's, I think it's her third witness statement, in which she does give some numbers about refugees? Because having accepted there can be a retrospective justification,
yes,
you can't simply look at the equality impact assessment. You would have been open to Hillingdon, would it not, to say, whoops, we forgot to evaluate this, but now that we've looked at it, we say A, B, C and D about it.
yes, it would. Now, that's been our position from the outset in this claim, because of course the 2016 amendments to the scheme were made after this claim was issued, and the discrimination was put forward as a reason why the scheme was in part unlawful. But one doesn't see in 2016 any explicit mention of non-UK nationals or refugees. So to come back to my Lord's question, what we have is an observation about how many self-identifying refugees Hillingdon were able to find. That, of course, says nothing at all about how many refugees were unable to get onto the scheme because of the rules, or indeed, in particular, why the individuals that are on the scheme were there. We actually asked some questions of Hillingdon about the 22 refugees identified as having been on the scheme to try and find out a bit more, but nothing was forthcoming.
Do we have that sequence of correspondence? I don't necessarily need.
It's not in the bundle, but I can ensure that that's available.
Well, only if you're relying on it, but you about unsatisfactory halfway house tell us about it orally and then say I haven't got the document.
I apologise. Well, what we can say is that there is no further information about those circumstances of the particular ones identified, or indeed anything to contextualise it as against. The final point I wanted to make on this is that when one actually looks at the officer's report, which is in the joint supplementary bundle,
Is it the 2013?
it is indeed, my Lord. I believe it's accepted that this is the only one that comes close to dealing with the discrimination in issue. I'll ask the court to turn to page 32, so that's behind tab 2.
Sorry, we're in the supplementary bundle.
This is the joint supplementary bundle, my lady, yes. So this is where the legal implications of the residency requirement are considered. The only point I wish the court to take from this document is that it only concerns ethnicity, and it only considers the question of mitigation in the context of ethnicity. And while we're here, the final paragraph deals with section 149 and the public social quality duty, where the conclusion is that the EA does not
Sorry, the
suggest...
final paragraph on which page?
Paragraph 33, I do apologise.
Page 33.
My lord, yes.
Yeah.
Where it said the EA suggests there would be no disproportionate impact. So there is clearly no, in my
Does
is the last sentence correct? Is the word not, should the word not be removed from it? Otherwise, as written, it's rather an awkward sentence.
Indeed it is, but one has to take it at face value.
Well, speaking for myself, unless anyone wants to make a positive submission to the contrary, I assume it must be a typo.
Well, no, because if one looks above, the sentence beginning as stated in the EIA, it is not anticipated that BME applicants will suffer detriment if the 10-year local connection requirement is introduced. So even the group that was being considered explicitly.
Yeah, well, that's a very odd conclusion in view of the report, which suggested they would suffer detriment.
The answer may be to that what Hillingdon do in the EIA, I don't believe it to be relevant to certainly Mr. Gullu's case, is they recognise that looked at in isolation, the residency requirements would affect adversely BAME families, but looked at as a whole, the scheme generally promoted BAME families. So
yes, well, that would follow from the second sentence of the antepenultimate paragraph. However, by permitting exemptions, you avoid the detriment.
that may well be the
I mean, that-
interpretation, yeah.
So that the not in the first sentence is an awkward not, because the impact assessment suggests that BME applicants will be disadvantaged by the 10-year residence requirement, but there will be exemptions, so that can be overcome. That's the not is there.
It's not a central feature of Mr. Gullu's case, so if I may, can we move on from that? And it may be that it crops up again in my learned friend submission. I'm grateful. The reference I did want to give to the court, sorry, I do apologise, it's in fact from the same document that we've just looked at, I believe. Just find it. Is the prompting at page 24. In the middle of the page about asylum seekers. I mentioned that yesterday, and so I ought to give the reference. But the issue of asylum seekers is closed down because they're not eligible. My lords and my lady, paragraph, footnote 42, which is in connection to paragraph 67, in addition to citing the Elias case and the Jewish schools case,
Sorry, where are you?
Paragraph 67 of Mr. Gullu's case and argument, footnote 42. I there reference the Elias and Jewish school cases as being where the principles are found without assessment and evidence, but I also give examples there, all of which are within the court's bundles of ex parte Winder and Samwell, MM and the Secretary of State for Work and Pensions, and RHA and Ealing, all of which are cases concerning residence criteria, and all of which are cases where the discrimination was established and found not to be justified in circumstances where there was no evidence put forward by the decision maker dealing with impact or mitigation. I'm afraid the case of HA ought to have found its way into the bundle, and I'm sorry that it didn't in the end, so I have produced copies of that just in case the court wants to look at it at background reading. it's also the principal first instance decision on the question of ambit, so it might be useful to have it in the background, so it's there. So, in summation, in 2013 and 2016, insofar as it was considered at all, the local authorities' approach to the question of discrimination against non-UK nationals did not focus on mitigation. And consistent with that, the pleaded case in the additional summary grounds said there was no discrimination by reference to one particular exception to the 10-year residency qualification rule, namely the fleeing violence one, reference for that, Gullu supplementary bundle, tab 4, page 36, paragraph 20A. So not that the discrimination was justified, but that there was none. And as I understand it now, the case put before the court is that justification is made out by reference to the safety valves, and that really is the only defence. That starts from the difficult position of not knowing what the scale of the impact is that one is seeking to mitigate. And so how can one properly judge whether or not the mitigation is sufficient to mean the measure is justified if one doesn't know the scale of the impact one is seeking to mitigate? It may not matter in this case because, as we looked at yesterday, the evidence is that none of these measures have positively impacted on non-UK nationals or refugees. Paragraph 71 of Mr. Gullu's skeleton argument is the place for the references for that. And the conclusion that Mr. Gullu therefore reaches is that when judged according to the evidence, it is clear that the safety valves do not dilute, still less remove, the disadvantaged refugees or non-UK nationals, for that matter, are caused by the residence criteria. And I sought to demonstrate in my answers to questions yesterday that neither are those rules designed in such a way that they obviously would impact or assist refugees. My understanding is, my learned friend's position is that that does not matter. The mere presence of those safety valves is enough to justify or make out the justification defence. Mr. Gullu's position is at this point completely aligned with the reasoning of Mr. Justice Supperstone in TW at paragraph 56. We say that if the safety valves do not assist the affected group, they cannot assist in justifying a discriminatory measure against the affected group. And therefore, if my learned friend is wrong in his attack on Mr. Justice Supperstone's reasoning in TW, then in my submission it must be right that the appellant's arguments in Mr. Gullu's appeal are correct.
Yes.
My Lords and my Lady, at paragraph 73, I then deal with 3 cases that are relied upon by the local authority to support its proposition on safety valves.
These are all first instance cases.
The first 2 are indeed. RH is the only one which is not.
Yeah. We weren't taken to either
No.
of the first instance ones.
They are referred to in my learned friend's skeleton argument.
Yes.
It may be the appropriate thing for me to do at the moment is just to refer to where I deal with them in my skeleton, where I make the points that none of those cases would support a proposition.
So it must be up to you, but if time is short, arguing about first instance cases which are only illustrative anyway, it doesn't seem to be a very good way of using it.
I understand that. Can I therefore deal with the RH case, which is the Court of Appeal case, which deals with this question? I hope to be able to deal with it briefly. It's behind tab 30 in the authorities bundle, which is in the first volume, second volume. schemes in issue, the WHPS, which prioritise working households, and an MTPS, which solely concerned transfers. The argument was that WHPS discriminates indirectly against women, the elderly and the disabled. Paragraph 8, you see a bit more detail about those two schemes. They are sub-schemes contained within the allocation scheme. And if one sees at the bottom of paragraph 8, after the extract from the scheme, the relevant observation of fact, which is that of the 20% of the local authority's allocation that was put over to these two sub-schemes, 15% was allocated to the WHPS and 5% to the MTPS. If I could then ask the court to turn to paragraphs 44 and 45 and 47, and if I might invite the court to read those. I'd ask the court then to turn to paragraph 76. Last sentence before the extract, beginning, she says that. Then coming on to the decision, paragraph 82. Recognition that this scheme, the sub-scheme, only concerned 15% of the stock. Which was described as being a critical difference. And then paragraph 85, where it's abundantly clear in my submission that the reason the discrimination caused by the sub-scheme was considered justified was because the scheme as a whole was either neutral or promoted the very group said to be discriminated against. And the issue about a residual override was mentioned only really as a, if I might say, residual argument to back up the basic conclusion, and that is precisely how it's dealt with in the two first instance decisions too. It's exactly the same analysis. Pausing there, if I may, what is not said in this case is that Part 7 was a safety valve. That may have been because Mr. Hutchins QC, who represented Ealing in that case, was counsel in the Morris versus Westminster case, where he successfully persuaded Mr. Justice Sedley, I do apologise, to reject a similar argument which suggested that discrimination in the context of Part 7 could be justified by reference to another scheme, the Children Act 1989. The reference for that is in the Morris case, which is tab 45, at paragraphs 53 and 54. At paragraph 74 and 75, in my skeleton, I attempt to summarise what the principal difference is between those three cases relied on by my learned friend and this case. All of those three cases concern discrimination alleged against large protected groups, women, disabled people, homeless households, said to be caused by a relatively minor rule or sub-scheme affecting a small part of the overall stock, but against the backdrop of the scheme and taken as a whole or in the round actually benefited the very groups said to be particularly disadvantaged. And in none of those cases was a safety valve, properly so described, significant to the reasoning, whereas in this case concerns a relatively small group of UK nationals, refugees or Irish travellers, who are disproportionately disadvantaged by the dominant rule in the scheme, which affects the entirety of the stock and accounts for over 50% of the allocations. In circumstances where the highlighted safety valves have not assisted a single member of those affected classes. And it won't have escaped the court's attention that in all of the cases where the discrimination was made out, in other words, it wasn't found to be justified, public authority had advanced...
Sorry, can you speak up?
Sorry, I do apologise. In all the three cases where the justification defence failed, which were the ones I mentioned in the footnote, no statistical evidence was advanced at all demonstrating the scale of the impact, why it was justified, or what mitigation had been considered and rejected. And in all the cases where the justification defence had succeeded, the contrary was true. And the issue of an override was simply a reassurance, if I can put it that way. My Lords and my Lady, then turning to the judge's test, which I hope I can deal with very briefly, it's paragraph 78 of my skeleton, and of course it's paragraph 38 of Mr. Justice Mostyn's judgment.
I'm concerned about timings, even allowing for you 5 minutes short. We've had, let's start 5 minutes late. There's only 10 minutes left of your time. You said you were going to take a quarter of an hour on Article.
Well, I'll have to reduce that.
Well,
It's up.
If it helps me, Lord, I'm not going to be anything like the 2 hours that's on the timetable for myself. And if my learning friend takes another 20 minutes, half an hour, then I still think we'll be at least finished with me by lunchtime.
Mr. Wise, point noted.
I'll do my very best nevertheless.
Yeah, absolutely. Just quickly.
So, my Lords and my Lady, in paragraph 38, we're dealing with Mr. Justice Mostyn's application of the four-stage Bank-Mellett test. There is in the background this question about where manifestly applies. It's my submission, I understand Mr. Wise is likely to agree with this, that it certainly applies to 1, 2, it maybe applies to 3, but it definitely doesn't apply to 4.
You have Bank-Mellett in the bundle. I was looking for it last night.
I don't believe it is in the bundle. The test, if it helps, is repeated in footnote 53.
Yes, I don't want to, having said what I said about time, I don't want to go off on a red herring about it. I was just slightly surprised to find Bank-Mellett, which is a very different kind of case, as I recall, being treated as the right place to go for the test of the proportionality. He's making, as I remembered it, Lord Reed was making a somewhat different kind of point there, but I couldn't find a case in order to remind myself. Let's not spend any time on it now. I don't think there's any real doubt about the principles, but could we have a copy over lunch?
We may be able to do even a little bit better than that. What we may be able to do is just clarify the extent to which this test applies in all proportionality cases, or certainly in the cases that the court is concerned with just now. That if I can leave it at that at the moment.
Okay.
I mean, certainly that's the way it was put before the judges below, I think in both cases. And certainly at footnote 53 you have the references to how the test interacts with manifestly without reasonable foundation. And I don't necessarily believe there to be a significant relevant issue between the parties about that. The first reasoning given by Mr. Justice Mostyn in little 1 obviously focuses on what he considered to be the extent of the disadvantage, which, as we've already discussed, was erroneous, and therefore immediately his application of the test and my submission goes wrong. In little 2, whether or not the residency requirement is rationally connected to the objective of rewarding residents with a long attachment to the borough. Of course, the answer to that is yes, it must be. It wasn't disputed. In relation to 3, less intrusive measure in relation to non-UK nationals or refugees, Mr. Justice Mostyn describes it as being quite wrong. It's not really clear why Mr. Justice Mostyn thought that. Certainly there was no evidence to justify that conclusion in my submission. And indeed, with the greatest respect to my learned friend, that was not a case advanced by Hillingdon. Hillingdon have never said, in terms, that a lesser rule for non-UK nationals or refugees would unacceptably compromise the objective of rewarding long-term residents. Moreover, certainly in relation to refugees, as they are not a racial group, there can be no issue at all about positive discrimination. Now, in relation to non-UK nationals, the point is in my submission addressed by simply coming up with a rule which might be designed to offset the worst cases of disadvantage that the rule causes non-UK nationals. It doesn't have to be a rule which discriminates against UK nationals directly in the manner envisaged by local authority. I covered that to some extent yesterday in my submission to that remedy. And I do understand that the other parties are likely to say a bit more about that point because it may be said to be more directly relevant, perhaps, in their cases.
Sorry, just without going back to it. In fact, I think none of your cases relied on in the footnote at 52 we got. We certainly haven't got the recovery of medical cost case. Don't think we got A and B. We have got RC Islington, though quickly looking at para 81, it doesn't seem to make out what you say, but I could be wrong about that.
There is an argument about the extent of it manifestly. Is that the point, my lord?
Yes, I mean, I don't know how important it is at the end of the day, but if it's important, we need to have the cases.
Absolutely.
Yeah.
Perhaps a way to deal with this is to see what Mr. Rutledge says about it and then see if there's an issue. Just to make it abundantly clear that certainly when it comes to the 4th stage, the balancing exercise, there is no argument, I don't believe, that's being advanced that that's where manifestly bites. You are arguing.
There's a much more general question about the relationship between the manifestly without reasonable foundation test, which is developed in the Strasbourg case law and then applied in human rights cases here,
Yes.
and the proportionality test in the Equality Act. Now, I dare say these cases do consider that,
Yes.
but I'm not familiar with that line of authority, and if it may be something on which we need to be addressed.
Absolutely. I understand, and we'll make sure that this is sorted out, and I'll perhaps discuss it with my learned friends at the agenda to make sure that there's no absence of authority for the court that's relevant. My little d in my skeleton, I'm simply repeating the point that there wasn't any evidence that would have entitled, in my submission, Mr. Justice Mostyn to reject the alternative method in which it might have been possible for Hillingdon to reduce the disadvantage caused to non-UK nationals, because it wasn't considered and there simply wasn't the evidence to justify it. We've been through that.
And that carries through into Roman 4, where he's balancing the severity of the measure's effects. But if you don't know what they are, you can't balance them.
Absolutely. And you certainly can't do it on the basis of mitigation, which is not shown to address it at all anyway. The relevant test for this court, when seeking to intervene on a proportionality assessment by a lower court, is now established from the AR versus Chief Constable Greater Manchester Police case, which is at tab 21, in the judgment of Lord Carmouth at paragraph 64.
Sorry, say that again.
It's tab 21, paragraph 64.
Yeah, do you want us to read that paragraph?
I was most grateful, yes.
Yeah, well, we probably all have.
Yes.
Not very surprising.
Hugely helpful.
Not very surprising stuff.
No. But that's where we have the most succinct description of what the test is. In my solution. My lords and my lady, then PSED, very quickly, at paragraph 83 of my skeleton argument. Most of this has already been canvassed. And I would invite the court to have in mind, as of course it will, the officer's report in 2013, which we understand was then approved by Cabinet. We don't have the decision, but that was what Mr. Rutledge said on his feet, where the closest the respondent came to an evaluation of the impact on non-UK nationals was a comment in the 2013 impact assessment that the introduction of the 10-year residential qualification criteria will mean new residents arriving to the borough and or country will not be able to access housing registration. We've looked at that. Whether or not that simply describes the rule, what is perfectly clear in my submission is they don't go on to then consider how that impact might be measured, and they certainly don't measure it, and then they don't go on to consider how it might be remedied or mitigated, and they certainly don't go on to consider whether or not it ought to be remedied or mitigated. And that is a straightforward breach of the public sector equality duty. And the citation there is at footnote 60 from the lead case on public sector equality duty, which is ex parte bracking, which is at tab 25 in the authorities bundle.
Sorry, did you say footnote?
Footnote 60, it ought to be.
59.
Oh, I do apologise. Not quite why mine.
Doesn't matter, unless it'd be slightly worrying if we had a different version of yours.
Oh, certainly would be. Yeah, certainly worrying for me. Yes, absolutely.
But it is 59, is it?
It's 59.
Yeah, okay, but then it's the same, yeah.
What is a mistake, though, I'm afraid, is that the reference there to paragraph 25 in ex parte bracking should be a reference to paragraph 26. I do apologise.
The difficulty I have about public sector equality duty in this context is the likelihood is, I take your point that we don't have precise figures, that the non-British national group who are affected by the policy are very small. They're not subject to the two words about people coming from outside the country. They're not simply identified at all by those carrying out the impact assessment. It seems a heavy burden on a public authority having to assess the potential impact of a proposed measure, to have to identify possible impacts on what may be very small groups where the impact couldn't reasonably be anticipated without enormous and disproportionate research. Quite often, impact from groups of this sort is thrown up by consultation. One quite often sees that and can consult very widely with, if it's a local authority, both individuals and groups within your borough, and they throw up problems. Have you thought about this, that and the other? And maybe the authorities thought about them already, maybe they haven't, but when their attention is drawn to them, then they can do any further inquiries that are needed. There's no suggestion here that anybody said, what about the impact on non-British nationals, or indeed refugees? Is it an absolute breach if you can actually show there will be a disproportionate impact, or a potential impact, I should say? An absolute breach of the duty not to consider that impact, even if it wasn't reasonably foreseeable at the time.
If I may, the first observation I would make is, of course, it was raised in the consultation, and that point is raised.
Asylum seekers were raised.
No, sorry, people from abroad were raised.
Well, even that isn't quite non-British national, but still, I agree,
Yes.
it's very close.
Okay, well, that's the only point at which it's said by the local authority that they were alive to the potential impact. So, as I understand it, if they're going to treat people from abroad as synonymous with the UK, non-UK nationals, then it's not really open to local authority to say they weren't alive to it. If I understand,
Well, in a sense, this may be more a point for Mr. Wise because it's more relevant to the case of the Irish travellers. So if you want to duck out of it saying, well, it's clear they were broadly aware of the problem here, I don't think I can press you. But if you have anything interesting to say about it.
the only point I would then make is, on the one hand, there might have been reasonable excuse, reasonable explanation, I should say, why it wasn't looked at then.
Yes, it isn't at your point, Mr. Wise, just he isn't relying on the duty in his case. So.
No, but the only point really, the only reason the duty is really there, if I to be straightforward about it, is because of the line of authority such as Cole, which says that if you have also breached the PSED, it's even more difficult to justify any subsequent discrimination. And to a large extent, that point is made anyway. So I don't rely on the duties of freestanding.
I don't think this route is perfectly fair matter forensically. It's a make weight.
Absolutely. Yeah. I don't move away from that. I mean, it's 2013. If they'd subsequently shown it was justified by reference to other material, then nobody would be focusing on the 2013 points.
I mean, speaking for myself, it seems to me to be perfectly possible for public authority to comply with the PSED, but nevertheless overlook some particular group. But when challenged by that particular group, to say, well, now we've looked at it, we either accept that there is discrimination, or we don't, or there is, but it's justifiable, or whatever it is. But that wouldn't necessarily entail a breach of the PSED.
No, and judges in the administrative court deal with that all the time. It comes up all the time. Where it does seem there's been an equality impact that hasn't been assessed, often the response is to assess it and explain what the consequences are, but we don't see that here. And there's a very interesting comment by Lord Kerr in the Jewish schools case, which I cite at footnote 60, where Lord Kerr explains that one's got to be very sympathetic towards these decision makers, but at the same time, if there is a relevant difference in treatment that hasn't been properly considered, then one has to deal with it. And if it remains not considered at the point of determination by the court, then so be it. May spill into remedy, which is perhaps why this conversation is somewhat arid, because I fully accept that I'm not going to lose on everything else and then win on PSED. That's not going to happen, and I accept it.
Well, in that case, it's probably all we need to say about it.
It is. So, my lords and my lady, that leaves ambit in the Article 14 claim. The reason why the focus in the context of the Article 14 claim is only on the ambit question is because everything else effectively carries over. The two other distinctions that might be worth keeping in mind are that there's, of course, no even implicit consideration of refugees per se anywhere. Of course, I take the point they're not of themselves a protected group for the purposes of the Equality Act. But does that entirely explain why there isn't any material now which deals with refugees, apart from the statement, from the very limited information in Mr. Murphy's statement? My solution cannot, for the reasons set out in paragraph 65. And secondly, of course, when it comes to justification, insofar as it's necessary to do so, which in my submission it's unlikely to be, one can, of course, focus narrowly on the particular group of refugees rather than non-UK nationals. The ambit question is important, however, as a freestanding point, because, of course, there may be other cases where this question arises, and, of course, it has already arisen in several of the cases of first instance, and, of course, was the subject of limited discussion in RH. I've set out my submissions in writing in the supplementary skeleton, which followed the submission made by my learned friends in their skeleton argument to the effect that I hadn't properly articulated why it was said that the authorities that have come since RH demonstrate in the appellant's submission that, with the greatest respect, the Marshal of the Rolls was correct in his conclusion that decisions about the allocation of social housing fell within the ambit of Article 8 and therefore triggered the Article 14 equal treatment duty, and that it's indeed the decision of the Master of the Rolls that should therefore be followed. The cases behind tab 30, we've obviously already looked at it in the context of safety valves. we see the reasoning of the Master of the Rolls based upon the citation from Mr. Justice Goss in the HA case, paragraph 29. I could just ask the court to read paragraph 100, the citation, paragraph 29 from HA, and then paragraphs 101 and 102. So in very broad terms, Master Rolls was drawing a distinction between the two schemes. The one that was about transfers between social housing tenants didn't fall within the ambit because it had nothing to do with family life, whereas on the contrary, the allocation of social housing did.
When the Master of the Rolls speaks in paragraph 102 between F and G of their right to permanent accommodation, what right is he referring to?
That's at footnote 4 of my supplementary skirting, where I explain with respect what the Master of the Rolls was doing by referencing to a right.
Sorry, I haven't written it out. Supplementary skeleton. So sorry, I certainly have got it because I have read it, but I can't lay my hands on it now. Is there a spare copy to save time? No doubt when the moment you find it, I will find it. I find I predicted correctly. I've now found it. Footnote 4, did you say?
Footnote 4, my lord, yes.
Yes, but Bar in the UK was concerned with homelessness and Part 7.
Yes.
So when the Master of the Rolls talks about a right to permanent accommodation,
Yes.
where does he get that from?
The right to permanent accommodation he is to some extent describing the conclusion in this point. What he's referring to in my submission is the additional rights that are said to fall within the ambit because they constitute a positive modality of the human right. He is not describing a human right to permanent accommodation, absolutely not. And we know that because if one were to read the preceding paragraph, one would see that everybody starts from the understanding and the premise, as indeed did Mr. Justice Goss, that there is no right to accommodation of any description under the European Convention of Human Rights. That is absolutely clear, and nothing in my submissions will detract from that. Indeed, nothing in my submission, the conclusion of the Master Rolls, does either. It's absolutely clear. I'll come on to explain why that's so, if I may, but what I understand the Master Rolls must have been referring to, because it's the only way to make sense of the judgment, is the additional rights falling within the general scope. And those additional rights are not human rights, they're entitlements that a state decides to grant to some people, which fall within the ambit of Article 8 because they are connected to the rights that Article 8 protects. And therefore, if the state is going to distribute that particular social entitlement, it must do it in a way which is non-discriminatory. or, to put it in the Article 14 language, guarantee equal rights to it. And the passage I've taken there from Ex parte Bar, I've used Bar because that's one of the authorities referred to specifically by Master of the Rolls, but it's repeated everywhere in the Strasbourg cases dealing with Article 14 because it's just stating the principle. But what we absolutely know about Article 14, and I don't believe there to be any issue about this, is that it is only engaged where the facts of the case fall within the ambit. But to fall within the ambit is not the same thing as interfering with the substantial right. That's confirmed without any doubt at all by Lord Wilson in Matheson, which is in the bundle, paragraph 17. I think it's in the bundle.
Is Bar? Oh, yes, it is 52.
Yeah, Bar's there, and I will be coming to that in due course. But with the greatest respect to the Master of Rolls, it's inconceivable if one were to read the judgment in full. The Master of the Rolls is saying, well, I've decided, in fact, European Convention on Human Rights gives everybody the right to permanent accommodation. That's definitely not the ratio of the decision.
But I still, there isn't a complete answer to my Lord's question, is it? Because you accept he can't have been meaning that Article 8 itself gave a right to permanent accommodation. But what then is the right of permanent accommodation to which he is referring, which falls within the ambit of Article 8, albeit not guaranteed by Article 8?
It's the same right that anybody enjoys who's seeking to obtain priority on a housing allocation scheme. It's never, in fact, a right to property. That's absolutely true about Article 8. It's a way of, in my submission, simply making the point that when you're looking at a scheme that distributes a benefit, even when it does so, it doesn't guarantee anybody the benefit, which is what the social allocation scheme is about, it's still an entitlement. It's an entitlement to be considered part of the scheme.
Yes, so he actually, you say what he meant was the rights under Part 6.
Yes, fundamentally, yes, it does. Yeah. Sorry, I was seeking to draw the distinction between that and a right under Part 7, which can, in certain circumstances, crystallise into a duty to provide.
I take the point. The rights under Part 6 are of a peculiar character, of a different character to those under Part 7, but they are nevertheless rights, and you say that's what he must have been referring to.
Yeah, absolutely, yes.
Would that not have the consequence that the statutory exclusion of persons from abroad as being ineligible is itself a breach of Article 8/14?
It wouldn't be a breach. It might call for, in a particular case, justification. Not that anybody has ever run that particular case. This is only about equal treatment to benefits or social entitlements that a state decides it's going to provide.
Well, the state has decided that it will provide housing, or local authorities have a power to provide housing, but not to people from abroad.
Yes.
That, on your argument, that would be unlawful, wouldn't it?
Absolutely not, my lord. I'm terribly sorry. I'm not following why that would be so. Equal treatment under Article 14 doesn't mean everybody has to be treated exactly the same. It means any difference in treatment has to be justified. It's precisely the same process. I'm terribly sorry.
But you are accepting my Lord's point, except you say not a breach, you mean a breach subject to justification.
Yes.
An infringement. If you
Better way, yes, or engages. Yeah, yes. I mean, the language is often used of engaging. So if you're in the ambit, you trigger the duty to treat people equally unless you've got good justification for not doing so, if I can put it that way. Which is why there is such a broad degree of crossover between the Article 14 claim and the...
So when in Bar, it says in the reference you've taken us to in your footnote, it says it applies also to those additional rights falling within the general scope of any convention article for which the contracting state has voluntarily decided to provide.
Yes.
And you would say the rights that the state has voluntarily decided to provide are?
In this context, it's the local authorities' decisions to have allocation schemes distributing social housing. The point being that if...
That morphs into a right to accommodation, you say?
No, I think the term right is being used by the Master of the Rolls there is a sort of way of encapsulating the rights one enjoys under the scheme. It doesn't mean a right to a unit of accommodation, if I can put it that way.
Well, I think you said it is a right to be considered. I think I've written you down as saying
Yes.
earlier. And it is, and I think, though this I think was me putting words into your mouth, a right of a peculiar character. It's a different, I'm really just feeding back what I understood you just to be saying. Under Part 7, you have in certain circumstances an enforceable right to be given accommodation.
Yes.
Under Part 6, there are no such rights. There are duties on a local authority to allocate social housing according to certain principles.
Yes.
Some left very general, but others, it's even more complicated, that under principles which it has to state in a scheme.
Yes.
And there are no individual rights under Part 6, except if you are in one of the classes of people to whom the scheme potentially applies. You have a right, in some sense, to be treated fairly in being considered for such a scheme. That, I may not be expressing it entirely correctly, but that's essentially the point I thought you yourself were making to us.
Well, it's indisputable, but with the greatest respect, I don't believe it to be relevant, and the reason why
No, we're just trying to work out what the Master of the Rolls meant.
Yes, I understand that, and there may be only so far I can take this, because it's abundantly clear, if one looks at the authorities the Master of the Rolls was considering, that nobody is contending that the Convention provides a freestanding right to housing of any description, whether it's Part 7 or Part 6. What the line of Strasbourg authority does is simply say that where a state does something which positively benefits the enjoyment of a right that is protected in the Convention, must do it equally. That is, as I understand it, uncontroversial and not in dispute. The question is whether or not it has done it fairly, having regard to the same sorts of considerations we've been looking at under the Equality Act. And in the first instance decisions, for what it's worth, that deal with ambit and Article 8 and the Article 14 discrimination cases, in none of those is it being suggested either that this is about a convention duty on the state to provide housing. We can see the contradistinction really in the statement itself from Barr. It says the prohibition of discrimination in Article 14 thus extends beyond the enjoyment of the rights and freedoms which the Convention and protocols require each state to guarantee. So it's looking beyond what the Convention guarantees, and then says it applies also to those additional rights falling within the general scope of any Convention article for which the contracting state has voluntarily decided to provide. Now, you can't voluntarily decide to provide it if you're under a duty to provide it. That's the key distinction. Have we got that? Sorry, is Mathis on? My lords and my lady, the most often cited reference for this point is Lord Wiltshire in the Matheson case at paragraph 17, which is referred to by the Marshal of the Rolls, but unfortunately, I believe at paragraph 87, but I don't believe we've repeated it because I hadn't understood it to be in issue. And it may be by the time I finish my submissions, it's clear why that is so. But of course, if necessary, I can ensure a copy of Matheson is provided to the court. Can I move on from that point to the analysis about why it said the Master of the Rolls was correct and why subsequent authority confirms as much, if I may? To take it briefly, the observations made by Lord Justice Davis and my Lord the Vice President in the RH case were slightly different as to why they disagreed with the Master of the Rolls. And in light of the conversation we've just had, I have to accept that Lord Justice Davis, at paragraph 128, where he says that there is, for these purposes, he's not at present prepared to accept that there is, for these purposes, a right to settled or permanent accommodation protected by or within the reach of Article 8, is in my submission simply repeating the conclusion that he doesn't accept that the right to social housing falls within the ambit of Article 8. The first part of that sentence, that it isn't a right guaranteed by or protected by Article 8, is obviously correct. I don't believe anybody is making a contrary submission. The important point, perhaps, for certainly the appellant submissions on this point of that ambit is what Lord Justice Davis then says, which is that the over-to comment of Mr. Justice Goss in HA may be altogether too broad. And in my submission, what Lord Justice Davis meant by that was that it was too broad to say that family life can only be enjoyed in settled accommodation. So turning then to my Lord the Vice President's reasoning in RH, beginning at paragraph 132.
Tab.
Paragraph 132.
Tab.
Oh, tab 30.
Oh, still.
Still in RH, yes.
Sorry, beg your pardon.
Doesn't the example of a nomadic Irish traveller shoot this argument to pieces about not being able to enjoy family life except in settled accommodation?
Well, my argument isn't that. It's not based on that premise. And that's precisely why I'm going to show why it is that the subsequent authorities demonstrate the Master of the Rolls was correct. Because the language used by the Master of the Rolls is homelessness. I'll come on to what he, in my submission, meant by homelessness, but he said that it's related to family life. And what Mr. Justice Goss said was it's related to it because you can't enjoy family life without settled accommodation. And for what it's worth, I would agree that probably is too broad, but it doesn't matter, and I hope to be able to show why that's so. But it's absolutely right, if I may say so, my Lord, to focus on that, because that was the issue, really, of disagreement between Master of the Rolls and my Lord the Vice President, and indeed Lord Justice Davis, that Lord Justice Davis said, look, it's too broad to say you can't enjoy family life only in settled accommodation. And my Lord the Vice President said, well, I accept that you can't enjoy it in precarious accommodation.
Well, I didn't say you can't enjoy it. I think I said that, maybe I did, but you show me where.
It begins, I agree that family life cannot be enjoyed. It's just 2 lines below D.
Yes, I see. I did say that. But I think I didn't need to go quite as far as I put it there to reach the conclusion I reached in the next sentence. Because it could be within the ambit of Article 8, even if in some circumstances you could enjoy family life in precarious accommodation. But anyway, that's probably a distraction.
It may be, if I may say so. The really relevant point, perhaps, for purposes of the argument I'm about to make, is that my Lord Vice President obviously felt that if it were right that you can't enjoy family life if you're in precarious accommodation, that didn't mean the allocation of social housing engaged Article 8, because that wasn't about lifting people out of precarious accommodation. It was about giving people social housing in circumstances where they might already be accommodated by the local authority under Part 7, for example. And that makes sense because the Morris case and the Barr case both concern circumstances where the relevant rule in issue was preventing or making it more difficult for somebody to obtain Part 7 accommodation. And so in those cases it was found that because that impacted on family life, that fell within the ambit. And my Lord the Vice President was very clear in saying that effectively, to paraphrase, that he wasn't prepared to go further than had been decided in the Morris case, and say that the allocation of social housing also fell within the ambit, because it wasn't about alleviating homelessness in that concrete sense. It was about the provision of social housing. Whereas the Master of the Rolls plainly felt that the duties, such as they are, to people who are already in local authority accommodation, i.e. Part 7 accommodation, which is not settled as such, did fall within the ambit because they were still related to the enjoyment of family life. Not that, in the Master of the Rolls assessment, that the provision of social housing was a necessarily prerequisite to the enjoyment of family life. And what I hope to demonstrate now is the subsequent authorities have put beyond any doubt that a rule which offers a benefit which promotes the enjoyment of a right falls within the ambit, even if what it offers is not a prerequisite to the enjoyment of the right. And that is the fundamental point. Which means one can freely disagree with the statement of Mr. Justice Goss, as Lord Justice Davis did, and say that's too broad, but simultaneously find that the provision of social housing, which is secure, long-term, and of choice, necessarily falls within the ambit of Article 8 because its provision improves the circumstances for the enjoyment of, promotes the enjoyment of family life, and in my submission, private life. And the authority, which is the bedrock of that submission, I suppose, is the Smith and Lancashire case, which is another decision of the Master of the Rolls, which is behind tab 44. If I could ask the court to turn to paragraph 55. Just while the court's doing that, just by way of a bit of background, this is where the Master of the Rolls follows on from the decision of Lady Justice Arden in the Court of Appeal decision in Steinfeld, where Lady Justice Arden did a comprehensive analysis of the ambit cases, and indeed the Master of the Rolls not only adopted that, he also did his own analysis of those cases and came up with paragraph 55 as being the legal position as summarised as taken from those cases.
Do you want us to read 55 on its own or any more?
The only other part I would ask the court to read then is that the second sentence in paragraph 56 beginning with first.
Okay.
Oh, sorry, and the next sentence after that, beginning there is.
this is fairly traditional stuff, isn't it? It's not as if the law has moved on. This was the law of the time of H as well.
No, the point that would, yes, but there wasn't, I don't believe, full argument in H, but where there was some doubt prior to Lady Justice Arden's decision in Steinfeld, at the very least, and also to some extent in this case, and subsequently confirmed by the Supreme Court, is the last sentence of paragraph 55. And in my submission, what that means is it's not necessary to demonstrate that the denial of a particular social entitlement or benefit seriously impacts on the enjoyment of the substantive right, still less that the enjoyment of the right is not possible without that benefit.
Yes, but that's not really the issue here, is it?
What the test one is left with is the tenuous connection. And in simple terms, a measure which promotes the enjoyment of a particular right is obviously not tenuously connected to it. That's the whole point of the particular.
Surely the test is whether it promotes the enjoyment of a particular right. Then
Yes.
we've got to see whether the particular right is one guaranteed by Article 8.
Yes, absolutely.
And how is an entitlement of the limited kind that we've been looking at under Part 6, why is that a modality of the exercise of the right guaranteed by Article 8?
Because in my submission, it's abundantly clear that when it comes to the promotion of Part 6 social allocation, in the way the Master Laws found, it's still related to the right, because when one has secure, stable accommodation of one's choice, one is bound to enjoy conditions, be in conditions that would allow for better enjoyment of the right. And it's as straightforward as that in my submission. So,
Sounds straightforward to you, but not to me.
well, if I can put it this way, well, first of all, let's begin with what the issues protected by the right are. Obviously, the right to enjoy family life is one, and the second is the right to enjoy private life. And in my submission, the provision of secure long-term housing of one's choice, i.e. in the area of one's choice, etc., plainly does provide improved opportunities for the enjoyment of those rights. Now, just on the family life position, that is very well established now, insofar as the relationship between housing and a home and the enjoyment of family life is well connected. And I'm talking about connection only to the extent of establishing a non-tenuous connection. That's the test here. And in relation to private life, I make the same point. And I've cited there at footnote 16 the AMV Finland case, which is a useful one for seeing how the European Court of Human Rights talks about the core values that Article 8 protects. I've just asked the court to read that.
So shall I read what?
The extract from the AMV Finland case.
How do I find that?
At footnote 16 of the supplementary skeleton argument, I do apologise, which it comes from paragraph 13. So just to bring us back to where we are as tangible.
Have we got ANMV Finland?
Yes, it is. It's in the bundle at tab 50.
What was it about?
AMV Finland about restrictions imposed on the choice of accommodation on, just sure I've got this right, yeah, it was about a young person who was, I believe had a relationship with a social worker or some kind of carer, which restricted the choices about where they could live.
His foster family. They were going to place him hundreds of miles away from
I'm most grateful, my lady,
schools and
yes.
foster
very different sort of case.
Well, of course, yes. I mean, I accept that. I'm not relying on it to demonstrate the connection between housing and private life. I'm relying on it to show what the core value of Article 8 is in terms of private life, so that I can demonstrate that the provision of social housing plainly improves it.
Yes, but general observations of the kind you quote in paragraph 76 have to be understood in the context of the type of issue the court is considering.
I perfectly well, of course, accept that. That's,
Time is moving on.
it is. I'm essentially finished. The other references then I can give the court. The argument is set out in the skeleton. I hope as clearly as I can put it. The only references which are not in there is my learned friend took the court to the guidance that speaks to the purpose of social housing at paragraph 5, which in my view, if the court looks at that, it's simply not credible to suggest that the provision of social housing isn't about promoting the enjoyment of the sorts of rights Article 8 is there to protect. And if that's right, then it's also right that it should be distributed in a manner which is non-discriminatory. And that's the only reason we're looking at ambit in this context. It's to trigger the duty under Article 14.
Yep. Well, there we are.
And at paragraph 17, I make the point again, if I may, that this, of course, does not in any way mean the Convention itself guarantees the right to social housing. And then finally, my final point is in paragraphs 18 and 19, even if the court is not prepared to go that far to say any decision about the allocation of social housing falls within the ambit, a residency requirement, which is directed to reward people for making decisions to stay resident in a particular area, certainly does, because that has a very foreseeable impact on the sorts of decisions people make pertaining to family and private life. And I put the references there from RH and DA in my submission to make that proposition good. So that's my fallback position if the court isn't prepared to go so far. In RH, they were only considering the general. They were considering whether every allocation of social housing or any decision relating to allocation of social housing falls within the ambit. If this court doesn't want to go that far, then in my submission, it's open to the court to say, well, that's not the case, but where you're dealing with a residency requirement, that does fall within the ambit in the same way as it did in DA. I'm most grateful for the extra time. If I can just turn my back for one moment.
You're grateful to Mr. Wise rather than to us.
I'm most grateful to Mr. Wise.
My lord, my lady, I'm grateful for Mr. Bird to the extent that his submissions, so far as they impact upon the TW case, we adopt, and so in that sense that saves some time because he's travelled through some of the territory that I would otherwise have had to have done. Can I address the court firstly on anonymity? My lord, the Vice President raised this point at the outset yesterday, and of course the presumption is of open justice, and there wouldn't ordinarily be an anonymity order. Given this matter some consideration overnight and recalled the reasons why we sought anonymity in this particular case, the background to the TW case, of course, is the situation of a number of traveller families. When one looks at the evidence, you'll see that both of the families involved in this case have a history of travelling and friction with other travelling families. One of the reasons they want to settle down, particularly TW, is because they wish to leave the nomadic lifestyle to settle down, and particularly with TW, to ensure that her children have the sort of settled education that she didn't have. As a consequence of that, there's friction amongst the community. And it was thought at the time, and we would submit rightly so, that it was appropriate to anonymise so as their addresses weren't known to other families within the traveller community with whom there was friction. That is the simple point. And of course, TW has
not be sufficiently met by not including in the judgment any mention of their address, which frankly I think is unlikely we would have done anyway.
Well, yes. I accept that entirely, and that's the other point. Of course, at trial, one was never sure what was going to.
I do see
the judgment. We've now narrowed down to essentially legal issues. So, if the court adopts the view that there shouldn't be no longer be anonymisation, I just invite the court to be cautious and careful in the way that they adopt it. Otherwise, we don't have any particular difficulty with a non-anonymisation of the case. I can deal with the grounds raised by my learned friend fairly shortly. The court has our written submissions in our skeleton argument. I don't propose to repeat those or take the court to them at this juncture. My learned friend, Mr. Rutledge, departed significantly from his written case in his oral submissions. So what I propose to do is deal with the additional points that he raised yesterday, but nevertheless invite the court to take on board the comments that we make, the submissions that we make in our written submissions. Before I come to that, picking up one point that was raised this morning, the manifesto without reasonable foundation point. I wasn't proposing to deal with that because it isn't an issue in the appeal. But so as the court's aware of our position, Mr. Justice Supperstone sets out the relevant extracts in his judgment, particularly paragraphs 36 and 37, as to what we say the correct position is. The leading case is, we say, the A case, and Lord Wilson's speech in the Supreme Court in that case. Obviously a different context. I think that was one of the Northern Ireland abortion cases. But we say that matters not, because as a matter of principle, the correct approach is in that passage cited by Mr. Justice Underhill, paragraph 37.
What was concerning me, and perhaps only me, is not so much the case law about manifestly without reasonable foundation, of which there's a lot, and one can follow where it goes, but exactly how it fits into a case which isn't a Strasbourg case, but is an Equality Act case,
yes,
where a different set of
consideration
or approaches to the kinds of judgments that have to be made has been expressed differently. Now, it may be that they all come to the same thing. It's one of these areas where different areas of law just develop different ways of expressing the same principles. But I thought it odd that we had started with the whole case has been argued below on the basis of Strasbourg authority, when, to me, perhaps particularly as mostly an employment lawyer, under the Equality Act, I think in terms of the case law on proportionality.
It wasn't all argued on the basis of Strasbourg authority. There was a number of authorities that Mr. Justice Supperstone didn't say. The main domestic authority, Supreme Court authority, on point was the Astor Communities case. We haven't got it in the bundle because it wasn't thought that it was going to be an issue. We can certainly produce it for the court. That was Section 15 of the Equality Act case, I think, from recollection. But Baroness Hale said in that case the proportionality exercise for the purposes of the Equality Act was essentially the same as it was for the...
There you are. I wasn't aware of that. That perhaps
I did
answers
say
my
Mr.
point.
Justice
So what case is that?
Astor Communities.
Astor as in the flower?
ASTER Communities.
Well, I think you have the relevant quote. You don't have the case, but you have the relevant quote from it in the XC case, which is volume 2, tab 37, paragraph 82.
So paragraph?
82 of
Sorry,
XC,
which
volume 2, tab 37.
Which paragraph?
82.
Right. Well, that may be the end of the matter. That really the lines of authority are interchangeable.
Yeah, that's essentially what's being said. I'm grateful to my learning friend for drawing that to the court's
It's
sketch.
also, I think, right to say that in Bank Mellat, Lord Reed, introducing his four-stage test, refers to the judgment of Justice Dixon Oates as being the most clearest and most influential judicial analysis of proportionality within the common law tradition.
Yeah.
Well, I also noticed that.
But Astor Communities was specifically an Equality Act case, so that really does nail the point down, I think.
Say it again, sorry?
The Astor Community case was an Equality Act case.
It's probably not. It's probably a red herring then. But I'm grateful to have.
I understand.
Whatever one does with a red herring.
Right. Can I begin by making some overarching points with respects to grounds 1 and 2. Ground 1, in short, the submission made by my learned friend in short, is that the judge below was wrong to have required Hillingdon to have assessed the impact of the 10-year policy on Irish travellers specifically, not just on race generally. I think that encapsulates the point without being forensic with his skeleton argument. So, when one steps back from that, we'd make the following general points. Firstly, that Hillingdon's submission isn't supported by any authority. The court will have noted that my learned friend didn't take the court to the cases that he relied on in his written case for this point, and he seems to have abandoned his argument based on the Unison case, which, for the reasons we set out in our written submissions, was misconceived in any event. Secondly, we say that Hillingdon's case is nonsensical. We say that because impact on race, as they describe it, is meaningless. The protection is for people who have the protected characteristic of race. Everyone is of some race, so it's meaningless to say they will just assess in terms of race. There must be particular racial groups with protected characteristics. We expand on that somewhat in our skeleton argument at paragraph 14 for the court's note. The third point we make, that even if we're wrong on this, if Hillingdon is correct, it would lead to absurd results which run directly contrary to the purpose of the Equality Act. And in particular, we invite the court to consider the examples given by the Commission as to the consequences of Hillingdon being correct. To put it in very simple terms, on Hillingdon's case, it would be sufficient to assess the impact of a policy on black people, even if it discriminated against people of a Jewish background. It simply can't be correct, and runs contrary to the whole purpose of the Equality Act. And we recall at this point that the assessment, the purpose of the assessment, is to enable the decision maker to understand the potential impact of its policies on persons with a protected characteristic so as to avoid unlawful discrimination. That's the point. It's not just a procedural hoop that the public body has to go through. It has a real purpose. Now, if the assessment process is going to have any real purpose, it's got to be directed at ensuring that there isn't any unlawful discrimination or any discrimination that may well not be, they may not subsequently be able to justify. And in that context, it must be wrong, we say, for the obligation on the authority to only have to look at the generality of racial groups rather than the particular racial groups that are affected by the generality. That it's not appropriate for the public body to consider the generality of racial groups rather than specific racial groups who would be affected by the measure that they are promoting.
Doesn't that depend on how finely you drill down into these various groups? It would be unrealistic, would it not, to expect Hillingdon to assess the impact of its housing allocation policy on former residents of the Amazonian forest, who are indigenous South Americans.
But that picks up on your Lordship's point you made to my learned friend Mr. Burton earlier. Of course, if it becomes apparent that there's a group that has slipped through the net, then they can do that.
The EIA stage, and I can well see that at the EIA stage, it's not incumbent on a policymaker to consider every conceivable group with protected characteristics, but if challenged by a particular group, then to assess and, if necessary, justify indirect discrimination. But you are, I think, are saying that even at the stage of evaluation for the PCP has introduced, the policy maker must consider all possible.
Well, they should do, but Hillingdon's case goes further than that to say that they say that Mr. Justice Supperstone found that they couldn't justify the policy given that they hadn't done that assessment. Well, that's plainly wrong, because Mr. Justice Supperstone didn't take that view at all. He went on to look at the scheme as a whole, as he quite properly was entitled to do.
There is a, well, again, speaking for myself, I've got a little bit of doubt about that in Mr. Justice Supperstone's paragraph 53. It's really the last sentence of paragraph 53. He quite rightly says that Irish travellers weren't considered in the EIA. It's the word therefore in the last sentence of paragraph 53, which just raises a slight doubt.
And if I can add, the other slight doubt to me comes from paragraph 59.
Well, if I can take one at a time, Milo, can I if we can just deal with paragraph 53, if you don't mind. The last sentence there is merely a statement of fact in our submission. No consideration has therefore been given as to whether the council had struck the correct balance between the important point that
has therefore, that sounds like the present.
Well, it hadn't even at that juncture. It was only when they did the assessment that was found not to be adequate in the TW2 case that Hillingdon actually considered the interests of Irish travellers. What's important, we would suggest, is what flows from that finding in the last sentence of paragraph 53. What flows from that? And we saw from what Lord Kurd said in the Brewster case, which is settled law misbehaving and so forth, a number of cases to similar effect, that where an authority hasn't considered the impact and done the balancing exercise, the deference owed to the public body is commensurately
That's
reduced.
That's a distinct point, which he goes on to make at paragraph 54.
Yes.
But that isn't the totality of the point.
No, my lord is going to go to, was it paragraph 59?
Yes,
you were
well,
concerned
it's
with?
the penultimate sentence in paragraph 59, where, and I tried to tease this out with Mr. Rutledge. Paragraph 59 seems to be a sort of summary paragraph, and after saying Irish travellers are significantly less likely members of other racial groups, that should be, to have resided in a particular location continuously each year. So essentially, so he's setting up the prima facie indirect discrimination.
Yes.
He then says, however, there's no evidence that the council sought to assess the extent of the disadvantage of Irish travellers, or to consider whether it was justified, or what might be. What he ought to be saying is, however, no evidence has been produced to me that allows me to assess the extent or consider whether it was to be justified.
He may well it may well have been better for him to have said that, but the point, the simple fact is that no evidence was produced before him, and that's not a point that Hillingdon are making.
I think, just following on, I think in a way, well, it's understandable why he expressed himself in that way. If you go back to paragraph 42, because he recalls he asked Mr. Rutledge what's relied on to justify, answer, the historic documents.
Yes.
So,
And there wasn't any.
in a sense, this point doesn't matter, because what was relied on was what the council did before the PCP, the amended PCP, was introduced.
And there wasn't anything else.
Yeah.
Sorry, we were at cross purposes. That was the point I was trying to make. Yeah. Yes. So, in that respect, we would say that Mr. Justice Supperstone's approach was entirely conventional application of accepted principles on the facts that he had before him. In short, with respect to ground 2, this is what's called the safety valve issue. You will have seen from our written submissions that we have some difficulty with the term safety valve. Safety valve isn't a term that's either in statute or guidance, and it's in truth, it's only a term that has recently been introduced by Council for Local Authorities in cases such as this, most of which the court's now seen. And we need to be careful with the language here in our submission. And I see that Mr. Justice Mostyn was somewhat anxious and concerned about the use of the phrase safety valves.
Has it seeped into written material produced by local authorities? I mean, I don't mean skeleton arguments, but I mean...
Not so far as I'm aware, my lady. Not so far as I'm aware. My learned friend would know better. Would know better. But one, regardless of that, one has to consider what exactly we're considering. What we're really concerned with are features of the scheme that mitigate the disadvantage or discrimination. And when one puts it in those terms, you'll see that what precisely we are looking for in the scheme as a whole. So it's a feature of the scheme that minimises the disadvantage that's relevant to justification for a discriminatory measure. Now, my Lord was quite correct yesterday when he said that mitigation isn't the same as justification. That's obviously right. But it's inevitably very relevant to it. Now, a great deal of my learned friend's submissions yesterday was concerned with the scheme as a whole, the Housing Act scheme, Part 6 and Part 7, and the allocation scheme. And I think it's a fair reflection, a fair characterisation of the submission to say that the scheme as a whole, Hillingdon are saying, provides adequate protection for my clients, and therefore they're not particularly disadvantaged. I think in summary, I think that's what it comes to. And the submission was couched in terms of fairness. My own friend used that word on a number of occasions. But of course, we're not concerned with fairness in the general sense. We're concerned with discrimination, which obviously is a particular type of fairness. But fairness, in general terms, isn't enough when we have an identified and accepted discriminatory measure. And so, even in that context, we look at what the particular benefits, the particular practical benefits there are to my clients, because we haven't really heard much about that in court. And there's three practical benefits or disbenefits of being excluded by the 10-year rule, practical benefits that would flow if they were able to bid for Part 6 accommodation, as distinct from provision made under Part 7, the temporary accommodation provisions. Three practical things: security of tenure, affordability and location. On security of tenure, Part 6 accommodation, as we know, is generally settled accommodation. My learned friend said that it is generally now for 1 year. Hillingdon's policy, which was before the court below, we've got copies in court if necessary, is that Part 6 accommodation will be extended until the youngest child of the family leaves school. And one sees immediately with TW that that's, what, another 16 years, the youngest child's 2, maybe 3 now, 15 years, or whatever, considerable length of time. Temporary accommodation is usually 6 months. PRSOs are usually 12 months, although in TW's case it's 2 years. Doesn't matter exactly how many months, the point is the same. The security of tenure under Part 6 is obviously significantly greater than it is under Part 7. That's the first point. Affordability is the next point. Part 6 accommodation is either council housing or housing association housing, put it in simple terms. Rent for council housing and social and housing association accommodation are generally much cheaper than they are in the private sector, and I think the court can take judicial notice of that. There is evidence that we can produce to prove it, but that's another real factor. And location.
Your comparison is with the private sector, not
Yes.
with Part 7 accommodation.
Part 7 accommodation is in the private sector.
Yes.
Generally, not always, not necessarily, but generally.
I don't think we've had evidence about this, or if we have, I haven't picked it up. I had assumed that the obligation under Part 7 is in effect to provide the beneficiary with accommodation that they can afford.
Well, the obligation is to provide suitable accommodation in, I think,
Yes.
section 193, and the guidance says that suitable should be affordable accommodation. But that's a different question than whether the accommodation is dearer in the private
So
sector.
are you actually saying that, based on evidence, that Part 7 accommodation maybe, often is, I don't know how you put it, more expensive than equivalent Part 6 accommodation?
Best I can do,
Where's the evidence?
I'll hand a copy of this up to you. This is Hillingdon's tenancy policy, my lord. Was it difficult? It was in the papers before the court below, I'm told, those who sit behind me. And it says, paragraph 4.2 at page 5, our homes are let at rents that are lower than those charged by private landlords or by registered providers for affordable rent homes, and that means that people have fewer worries about their housing costs and can focus instead on other things that help them succeed, like training, employment, etc.
Oh, I've got no problem with that. That's what we all understand
Yes.
about Part 6 accommodation. But that's comparison with the private sector, you or me going out to rent generally. But Part 7, even if provided in the private sector, is of a rather particular character. And I'm not sure whether you're saying that there is evidence that Part 7 accommodation is more expensive than Part 6 accommodation.
Well, it's saying private landlords or registered providers.
Yeah, I know it is, but that's not meeting my point.
Sorry, I'm just being asked. I'm told from my solicitor who sits behind me that Part 7 is almost always provided in the private sector and is invariably.
I know that, that's not the point.
And the evidence of TW's case itself shows that, but we haven't got that before the court.
Shows what?
It was certainly in TW2. Well, the accommodation that she's now been moved into, the Part 7 of the PRSO that my learned friend referred to, provides her with a shortfall of about £6,000 a year.
Okay, well, fine, and then show me the evidence.
Yeah. Well, we'll do that over the adjournment. I was just making the broad point, frankly, which I think you can take judicial notice of, and the fact that social housing is generally cheaper and more affordable than housing.
Yes,
in
I'm sorry, but this may be another red herring, in which case I apologise, but that's surely not the right comparison. Because she is, and people in her position are being afforded Part 7 accommodation.
Yes.
And the question is Part 7 accommodation more expensive?
Yes, because it's in the private sector.
Well, that doesn't follow.
Sorry, I hadn't understood.
Right.
Well,
I don't want to spend any more time on this. I'm not ultimately sure that's central anyway.
no, I was just making brief points about the practical advantage to my clients, and affordability was one. Location is the security of tenure, affordability, location. It was, I think, recognised from the bench yesterday that certainly London authorities generally place people in temporary accommodation outside of London, and I think that is something the court can take judicial notice of. Part 6 accommodation is generally within the local authority area, whereas routinely, especially with respect to London boroughs, Part 7 accommodation is generally outside of the borough and sometimes a long way away. And I raise those points just so the court is aware of the real practical implications of this policy for my clients. This isn't an academic point by any means. Returning then to Melanie Friend's oral submissions on ground 1. It was said that the judge was wrong to have approached the case on the basis that Hillingdon failed to assess the impact of the residency policy on Irish travellers at the outset, and it was doomed, is the way in which my learned friend described it. Well, the justification wasn't doomed because of a failure to assess the impact at the outset. It failed because the judge, looking at all the material, including the so-called safety valves, found that there wasn't a justification. There's no... the authority are wrong to say that a failure to have done what they call a pre-assessment meant that there couldn't be a justification, because that's the way they place it in their ground one. That's simply incorrect. My learned friend then went on to say, as I think we've just seen from Mr. Justice Supperstone's judgment, that the critical document was the 2013 impact assessment. Well, yes, it was the critical document, but it's only critical in the sense that it showed what Mr. Justice Supperstone described as the paucity and inadequacy of Hillingdon's evidence, and that was a conclusion that the judge was entirely entitled to arrive at. And so we say that Hillingdon's first ground of appeal, i.e. that is that Mr. Justice Supperstone found that Hillingdon couldn't advance a justification defence in the absence of the assessment we were just referred to, is simply wrong. What happened, as we know, is that Mr. Justice Supperstone also looked at the scheme as a whole, including what were presented to him as being safety valves. So when we look at Mr. Justice Supperstone's judgment, if we can just turn that up again.
This is on to ground 2 now, isn't it?
Yes, my lord, yes. Ground 1 is simply wrong, we say.
Yeah.
Simply wrong.
You say it's not what Mr. Justice Supperstone did.
Yes.
If he had done it, you accept it would have been wrong, because you accept there can be ex post facto justification.
Yeah, absolutely.
So that's not in fact what he did.
Absolutely, my lord. Yeah. He made a decision on all the evidence before him, as he was obliged to do. If we look at the judgment, we see at bear with me.
56, isn't it?
No, it's a slightly different point I'm looking for. No, it's 48. I don't think we've looked at this paragraph. This shows the way in which the point was put in the court below. And we see, if we look at the second page, page 73, relevant to that question is the question whether the scheme as a whole contains any or sufficient safety valves, is the way it's put. Specifically in relation to protected characteristics of race, Mr. Rutledge relies on the following provisions contained in the scheme: ring-fenced lettings for homeless households, local lettings policy, care leavers, specific schemes for gang and domestic violence, etc., and specific schemes for gang and domestic violence, etc. Further, for any person suffering from unusual hardship, there's a number of safety valves. They include allocations outside the choice-based letting schemes, that is direct offers, and also hardship grounds. And so, at first instance, the case put by Hillingdon was much broader than it's now put. They prayed in aid a range of factors that were in the scheme. Now, I think, as we understand it, they are restricting those to the hardship grounds and the direct lettings. But you'll see the approach of Hillingdon before the court was very much a scattergun approach. At any policy that could conceivably help anybody who may fall into this group of people. There was no evidence that any of these provisions had in fact assisted any Irish travellers. But we know now that we're reduced to safety, to direct lettings and hardship. But as my Lord the Vice President observed yesterday, with respect to the hardship grounds, that doesn't address the specific discrimination that we are concerned with. And the examples given in the policy show that the hardship is fairly narrowly defined, and probably deliberately so, because otherwise it would open the door for presumably very many applicants to apply during that under that provision. But also the direct lettings provision. If we go back to the scheme, we've got that in the supplementary bundle. If we call, I think the tab at the end of that bundle, tab 9. The direct letting scheme is page 183. And you'll see that that isn't a provision that provides a general exceptionality clause, as you see in many policies, a discretion that can be exercised by the director where appropriate.
So sorry,
Page 183.
Of which bundle?
So supplementary, joint supplementary bundle.
Joint supplementary, sorry.
Sorry, I should have said that. Final tab, tab 9.
Yep. Yep.
If you go to page 183, your lordship's seen all this, but I'm just drawing a particular feature of it out. You'll see section 6 of this policy, allocation outside choice-based lettings, that's direct offers. And it goes on to say, in certain specified cases, an allocation may be made outside of the choice-based letting scheme. These are. And so these are certain specified cases. This isn't a general discretion. It's in these particular circumstances that are prescribed in those bullet points. I'm not sure how many there are there, about 20 or so. And so that provision also isn't directed at the discriminatory provision that we are concerned with, and neither does it assist Irish travellers at all. And one of the submissions that my learned friend made yesterday was the fact that EM, Mr McDonough we can now call him of course, made an application to the hardship panel, that even though that application was refused, it shows that the hardship panel is effective. Now, for our part, we simply don't understand that submission. It doesn't make any sense at all. In what way does the fact that my client made an application under that particular provision and was unsuccessful under it show that that is an effective safety valve, as he calls it, to address the disadvantage that that Mr McDonough in particular and my clients in general are subjected to?
Is your point that if he hadn't been required to comply with a 10-year qualification period, he wouldn't have had to make the application to the hardship panel at all?
Probably not, no, my lord.
It wouldn't have been in Band D.
Well, it certainly wouldn't have been in Band D.
Band C would be, whatever it was.
Might have been in Band A, who knows?
Yeah.
It's not assessed. But his circumstances are quite dire, as you see from the facts, from his evidence. And so, we consider conceptually what we're concerned with here. Discrimination, of course, is a relative concept. A person is less likely to receive a benefit than another person. B, an Irish traveller, in this context, is less likely to receive a housing allocation than applicants for housing generally. So when we're considering the scheme as a whole, we're looking at the features in the scheme that lessen that disadvantage. They're not just features in the scheme that make it less prescriptive. And a measure that provides no more benefit to Irish travellers than other applicants can't narrow the gap. And as such, it doesn't mitigate the disadvantage. And that all goes to showing, we say, that Mr Justice Supperstone was entirely correct in his approach to this case. And it would be nonsensical if the converse were correct. My learned friend then made submissions, the court will recall, about what the court was to do in these circumstances, and there was some discussion about what measures Hillingdon could take to mitigate this disadvantage or prevent the disadvantage occurring at all. Well, the first point we make on that this isn't a ground of appeal. And the second point is that the difficulties arising from a legal obligation not to act in an unlawfully discriminatory manner are for the authority to resolve. There was reference, my learned friend referred to our submission in the court below, that they could have adopted a lesser period, and of course they could have done. The context of that submission, of course, was that we said that they could have adopted a less intrusive means of achieving its legitimate aim. It was in that part of the justification structure. But nevertheless, that was a suggestion that we made. But there are any number of different ways in which a local authority can deal with this kind of problem. I expressed some caution in setting those out for the reasons that Mr. Burton said yesterday. But recognising also the court will want to know in practical terms whether there is a real way of doing it, considering this. The authority could, for example, have made a provision that families who have a history of being of no fixed abode be exempt from the 10-year rule or the banding uplift. Now, that wouldn't be specifically directed at Irish travellers, but they would benefit from it. Because, as they say, direct discrimination would be unlawful. But indirect discrimination isn't unlawful so long as it's proportionate. And we get that from section 158 of the Equality Act. And that's a very important part of the Equality Act scheme, to ensure that disadvantaged people are given a leg up and the opportunities that the rest of the community have. Now, we addressed section 158 raised section 158 in our written submissions. That my learned friend hasn't addressed that at all. So, but the point is that there are practical things that authorities can do to avoid or minimise the disadvantage or discrimination. Finally, on this point, my learned friend's written submissions made great play of the cases that my learned friend Mr. Burton took the court to earlier this morning. He didn't go into those in oral submissions. That was the C and Islington case, the XC case, and also the H and Ealing case. We adopt what Mr. Burton, respectfully adopt what Mr. Burton said about those. They have to be looked in their context. And certainly in the first of those two cases, they are cases in which the judges had found that there was justification in any event, without looking at the extraneous features that my learned friend alludes to. They were confirmatory factors rather than determinative factors in finding that the measures in play in those cases were justified. And so they don't provide any succour for my learned friend's submission that safety valves generally are adequate justification, in contradistinction to Mr. Justice Supperstone's submission that any such features of the scheme have to address the particular disadvantage or discrimination that results from the scheme, the measure in the scheme. So we say it's a very simple and short point. With the second point made by my learned friend, it's simply wrong. If one conceptually considers what we're looking for, what the court's looking for, and looking at the scheme as a whole, we're looking for measures that mitigate the disadvantage, and that's exactly what Mr. Justice Underhill does, and he was correct to do so. So we say that on that point, the appeal should be also be rejected. With respect to ground 3, a little bit more to say on this ground. You'll recall, can I take the court back to the judgment below, and you'll see in page 77 of the bundle. This point starts at paragraph 73. And can we pick it up at paragraph 75? You'll see that the judge says, Mr. Rutledge submits that the evidence demonstrates that the council had regard for the need to safeguard and actively promote the welfare of children, and cites there the 8C case. The court wasn't taken to the 8C case, and I think it's important that we do look at that, because that's the latest Supreme Court authority that touches on Section 11. It's in the first volume behind tab 20. First, can I just invite the court to read the head note to get the context in which this point arose? Put shortly, it's concerned with financial support for children of what are known as Zambrano carers. Zambrano carers are generally carers who don't have British nationality, who then have children that do have British citizenship.
Well, if you really want to read the whole,
it is rather long, which is why I was trying to.
What you've just said is enough, isn't it?
I think it probably
yes,
is, my lord. So we're concerned with the welfare of children and support for them. The main judgment is given by Lord Carnwath. We see that starts at page 1490 of the report. Lords Wilson, Sumption and Clark agreed. If we can then look at paragraph 33, this page 1500 of the report. You'll see in this section of the judgment, Lord Carnwath is dealing with section 17, that's section 17 of the Children Act 1989, of course, and sets out a bit about that. Now, the financial payments that were made to these children would have been through section 17, that's the route, section 17.6, I think it is, provides the power for local authorities to give financial support. And then if we can go to paragraph 37 at 1502, first sentence, it must always be remembered the primary objective is to promote the welfare of the children concerned, including the upbringing of such children by their families, etc. And then if we go down to the last sentence of that paragraph, on this aspect, I agree with the observations of Baroness Hale of Richmond at paragraphs 43 to 46 of her judgment. Baroness Hale's speech then is follows directly on from that. Now, if we go over the page, you'll see that she picks up the section 17 point at paragraph 43. But it's paragraph 46 that where section 11 bites, and you'll see what she says there. In carrying out that review, that's a review, sorry, I should have just taken to the end of paragraph 45. We are told that it is still the position today, this is the about the previous proceedings, although of course the local authority may carry out a further review of the children's needs. So the review referred to at 46 is the further review of children's needs for support. In carrying out that review, if we can return to that, the local authority will no doubt bear in mind not only the duties under section 17 but also the duties under section 11 of the Children Act 2004 to discharge their functions having regard to the need to safeguard and promote the welfare of children, and the duty under section 175 of the Education Act to exercise their educational functions with a view to safeguarding and promoting the welfare of children. Importantly, safeguarding is not enough. Their welfare has to be actively promoted. Section 175 of the Education Act 2002, incidentally, is in very similar terms to Section 11.
Do you want us to read this paragraph to ourselves? Or do you want to?
Well, I was only going to take you to there. But
I see. So sorry. No, well, that's fine.
The rest of it.
Yep.
But I was anxious to emphasise that, to see where that phrase, which there's always a danger of these phrases becoming mantras if they're not put in proper context,
yes,
my lord, which is why I wanted to carefully take you through that. And so you'll see where that active promotion, obligation for active promotion comes from, and which was accepted as being, on which the Hillingdon said in the court below that they complied with.
But can I just understand how this argument fits into the overall scheme of the case? If you succeed on the ground that there is indirect discrimination against Irish travellers which has not been justified,
Yes.
Does the argument based on the Children Act add very much?
Yes, because the authority, if we're right on grounds 1 and 2, then the authority will have to go back and redraft their scheme so as to ensure that it doesn't discriminate.
Yes.
In doing so, they will also have to comply with their obligations under Section 11 of the Children Act.
If you were to lose on grounds 1 and 2,
Yes.
how does ground 3 get you home?
Well, they will have to go back and consider the policy and under the in a Section 11 compliant way in any event, regardless of grounds 1 and 2. They're freestanding, completely different statutory regimes. What then is the consequence of?
Can I just be clear about this? What do you rely on as a breach of 11.2? Other than what you rely on as under the head of indirect discrimination, what facts or considerations?
Well, I'm going to come on in a moment. I may not be able to do it before lunch now, but it won't take very long. There's 2 cases that have considered Section 11, 2 Supreme Court cases that have considered Section 11. It's the HC case that we've just seen, which is the latest one. The other one is the Unzola Meso case that my learned friend took you to yesterday. In our submission, he completely mischaracterised that case, and I'm going to tell you why in due course. But in summary, that shows that there is an obligation on public bodies who have dealings with children, and there's a list of public bodies of which, obviously, local authorities with children's services responsibilities are part, have to be able to demonstrate compliance with Section 11. They
But
simply.
what is it about the policy that fails to do that?
Well, they haven't even considered the interests of the children of travellers.
What is it in the policy that you attack?
Pardon?
What is it in the policy that you attack?
Well, it's the practical implication that bites, my lord, and the facts of this case bear it out very well, because if TW was able to bid for properties, then she would be able to get secure accommodation, from which her children could then settle at school and so forth.
Well,
As it happens, she hasn't been able to.
Let's pretend for a moment that TW is not an Irish traveller.
Yes.
She is white British, but she can't satisfy the 10-year residence requirement.
Yes.
But she's got children.
Yes.
I mean, do you say that the fact that she has children means that she should be exempt from that?
No, it doesn't mean that at all. What it means is that what Section 11 requires is for authorities in formulating policies and in individual decision making, have to actively promote the welfare of children. And now that provision was brought in for good reason, my lord. You'll see it's the 2004 Act, obviously some years after the 1989 Children Act, which is the primary act, as my lady is very well aware, concerned with children. It was brought in because the Children Act itself wasn't adequate to protect the interests of children. And it was particularly brought in fact, as a result of a recommendation by Lord Laming following the death of Victoria Climbay. That's by the by. So what Parliament is requiring of public bodies such as Hillingdon is a specific focus on the welfare of children when they're developing their policies. They simply haven't done it here.
Well,
It's
why
an
do you say they
important
haven't
obligation.
done it yet?
Well, there's no evidence. There's no evidence that they have.
Why is that? But they will know that all the families, they will know that a large number of the people affected by the policy will be families with children.
Well, first of all,
When you say they must have a specific focus on the effect of children, what
Yes.
does that mean in practice?
actively promoting. So when
Do they not actively promote it by having a fair,
when
non-discriminatory scheme?
when they they are certainly assisting in actively promoting by having a fair non-discriminatory scheme, but when formulating the 10-year residence rule, they should have had in mind the impact that will have on vulnerable children who would be affected by it.
Well, why will it have but that will be true about any of the restrictions. They will have an effect on all potential tenants.
The law requires them to have regard to the welfare of children with respect to all.
What I'm trying to get at is, what does that mean in practice? What does that mean other than having a fair scheme doing the best they can for all the people on the housing list, many of whom will have children?
A number of ways they can deal with it, my lord. And again, it's not for us to say how, but the scheme itself could incorporate specific provisions concerning, for example, school-aged children, particularly primary school-aged children.
What sort of provisions?
Well, it may be that preference is given to families with children of school age, or whatever. But they need to. They are obliged, as a matter of law, to address their mind and actively promote the welfare of children. Even if
I see that. I see that, but I'm trying, as you can tell, to see what that means in practice. It's absurd to suggest that the council wasn't aware that children were potential beneficiaries, and there are lots, as has been pointed out, lots of references to the position of children.
Yes.
So, to say they have to specifically bear in mind, or whatever your exact phrase, actively promote.
Well,
what does that? I mean, why can we say they haven't done that?
Can I give you? Well, because there's no evidence that they have. That's why we say.
There
can I
is
give you a specific example, my lord?
There is evidence they've done it. There is evidence they've done it. They have got a social allocation scheme, a scheme for the allocation of social housing, which provides, as far as resources allow, for a allocation of social housing to families with children.
No, well, and that's one of the points I was coming to about the 8C case. Of course, Section 17 allows for financial provision to be given to Zambrano carers and their children. But Baroness Hale goes further, and it's unanimous, by the way.
Don't worry about that. Keep on the point.
What she's saying there is Section 11 adds to Section 17. Now, Section 17 is quintessentially concerned with the welfare of children, obviously, in a far more profound way than the Housing Act is. So, but even then, Section 17 has to be applied in a particular focused way that actively promotes the welfare of children. The general powers were found not to be enough. There needed to be more. Parliament decided that the exercise of those general powers wasn't sufficient to ensure the protection and safeguarding of children. Now, after the adjournment, I'll take the court to the Nzola Meso case to see how that worked in practice in a real case.
Yes, thank you. Now, we're obviously behind the timetable, but not necessarily fatally behind.
I'm only going to be another 10 minutes, quarter of an hour, Lord.
Like that.
Yes, I'm happy to reduce my time as the intervener, because I think
it doesn't sound as though there's going to be any problem.
As matters presently stand, my best time is 45 minutes plus questions.
Good. 2 o'clock.
Good trials.